Now this one is from Zero Hedge, although I think it's authored by, yeah, Andrew Napolitano, Judge Napolitano, which I thought recently, hadn't he become a little kind of a turd against Trump, somewhat? I think of the same guy, but after reading this article, like, I can't argue with the article. It's a great article with a great opinion. And he titles it, "What is Wrong or What's Wrong with FISA?" The whole FISA court, again, it's a secret court where only federal agents, usually national security is of the greatest of importance in there. So it's all classified stuff, bringing all this information to a court and to a judge you don't even know exists, who may be allowing them to spy on you without you ever finding out. You know what I think a lot of people do, maybe including myself, because I'm a YouTuber and I've exposed some of this crap against the government, and I used to talk about the school shootings a lot, and maybe makes me wonder, wonderful JSNIP 4 ever got a FISA application to be spied on. Because after they're done, you should be able to do a Freedom of Information Act request and pull that information. Have I ever been the subject of a FISA application? Have I ever been get that information out? Because if you are, guess what? I bet there's a high probability that there's some made up bullshit against you or me in order for them to get that warrant to spy on all of us. Now, the way around that, again, was this huge database thing, I think, that John Here to Help talked about, this massive database. Maxine Waters had even tweeted about it a few years ago. We've got access to this database, the most powerful database ever. And whoever the next president is, Democrat, they'll have access to it. And John Here to Help says, yeah, it was a massive thing where you normally wouldn't be able to touch a database like this without getting a warrant or official approval through the process of getting that approval, again, typically through a court, to look up information on somebody. Well, no, they had complete access to this without even knowing who the hell was using it. So let's talk about the FISA court, the whole damn system. Congress enacted the Foreign Intelligence Surveillance Act in 1978 in response to the unlawful surveillance of Americans. Hear that? Why did we enact it? In response to the unlawful surveillance of Americans by the FBI and CIA during the Watergate era. So they've been spying. We're going to come up with FISA Court, the FISA system. This will fix the problem with all you guys breaking the law. You guys are the law enforcers. Why are you breaking the law? And it just helped keep it another layer secret. And they did it again. They've been abusing it. They never stop. I always say this, and I don't think I'll ever change. When they get caught, oh, we're going to do this, we're going to fix that. We've got a commission, the 9/11 Commission, the Warren Commission, the Banking and Loan Scandal Commission, the Iran-Contra. We got a commission. We're going to pass some laws so this never happens again. And they immediately go back to doing it right away. Immediately. As if nothing was said, no laws were passed. Nope, we're going to go right back into spying illegally. And then they'll get caught in another 10 or 15 year incompetence. And that's what we're hearing. Oh, maybe some incompetence at the FBI. No, you had a guy modify an email from the CIA. If he didn't modify that email, they would have not been able to get that warrant on Carter Page. But we got the FISA system. It's supposed to protect. It says right here, 1978. It was done in response to the unlawful surveillance of Americans by the FBI and CIA during the Watergate era. Speaking of the CIA, wasn't it under John Brennan a few years ago? Oh, the whole Senate and the Congress was being spied on. Oh, sorry, we were a mistake. Remember that? Remember that scandal? That was just a few years ago. Under John Brennan's watch, by the way. Like I said, they get caught. Oh, it was a mistake. We won't do it again. And they trust me. While he's speaking or whoever is speaking, they're continuing their spying on everyone they were spying on. President Richard Nixon, who famously quipped after leaving office that when the president does it, that means that it's not illegal, used the FBI and CIA to spy on his political opponents. The stated reason was national security. Nixon claimed that foreign agents, physically present in the U.S., agitated and aggravated his political opponents to produce the great public unrest in America in the late 1960s and early 1970s, and thus diminished Americans' appetite for fighting the Vietnam War. Oh, so this is Russian collusion back then. Nixon claimed that foreign agents, nowadays foreign collusion was Russian collusion, right? Foreign agents physically present in the U.S. agitated and aggravated his political opponents to produce the great public unrest in America. Oh, blame it on a foreign power. You mean they're going by a blueprint when they do this? Yes, that's correct. Which is why you hear Pelosi and them talk about, the Nixon impeachment thing, the Watergate. Yeah, we've got, our blueprint. Oh, I bet you do. I bet you do. This view, there are foreigners among us who wish to harm us, came to fruition during the presidency of Jimmy Carter, who pushed for the enactment of FISA. FISA's stated purpose was to limit, not expand, limit the government's surveillance powers by requiring the intervention and permission of a judge. Wait a minute, government surveillance is a search under the Fourth Amendment, and government searches already require warrants from judges. So what was new about FISA? The Constitution requires probable cause of crime to be demonstrated to a judge before the judge can sign a search warrant. That was the law of the land until FISA came along. FISA set up the Foreign Intelligence Surveillance Court, and it authorized the judges on that court to issue search warrants based on a lower standard of probable cause. Isn't that contrary to the Constitution? Yes, it is. But a challenge has never reached a non-FISA court federal court because the government has never used evidence that it admits was obtained from a FISA court warrant in a criminal case for fear that a federal court will invalidate the FISA standard. It gets worse. Because the FISA court meets in secret, and because only government lawyers appear before it, we have a dangerous recipe. Secrecy and no defense counsel produce tyranny. That combination has the standard for issuing search warrants, sliding even further down the slope of tyranny and absurdity. FISA established probable cause of foreign agency as the standard that government lawyers must meet. That morphed into probable cause of foreign personhood. That morphed into probable cause of speaking to a foreign person. And that morphed into probable cause of speaking to any person who has ever spoken to a foreign person. All of this happened in secret. This is the slow but persistent destruction of the right to be left alone and not spied on, which is ostensibly guaranteed by the Fourth Amendment, came about not only by secrecy in the absence of adversaries, but also by judicial gullibility and constitutional infidelity. Judges have a tendency to accept uncritically the unchallenged applications presented to them. Who's going to challenge it? There's no defense. There's no one that knows it's happening. It's only the people bringing the case. The FBI in this case against Trump. Well, you don't have enough here. Okay, let us go get a dossier. You still don't quite have enough there. Okay, we need to get some information from the CIA about this guy. Oh, he was an asset. No, we can't say that. The court will never issue us a surveillance warrant. We need to say that he was not an asset to the CIA. So I'm just going to take it upon myself as an FBI agent to change that email, modify it, and then send that in so that we can go ahead and get this warrant. Judges have a tendency to accept uncritically the unchallenged applications presented to them. This is an inherent defect for FISA court judges, whose decisions slowly and materially weakened the already unconstitutional FISA probable cause standard. FISA court judges have granted 99.97% of all applications for search warrants. All of this is presented as historical and legal background for an understanding of the report of the Inspector General of the Department of Justice on the FBI's use of FISA to surveil the Trump campaign in 2016 and 2017. That report released earlier this week concludes that the agents to the that report released earlier this week concludes that the original FISA statutory standard, probable cause of foreign agency, was met when Australian intelligence agents tipped off CIA and FBI agents to the boasts of one of Donald Trump's foreign policy advisors that he had ties to the Kremlin. The FBI then took that tip, added it to erroneous, incomplete, and unverified materials, and persuaded the FISA court to issue warrants to surveil the Trump advisor and the campaign. The DOJ IG found that the beginning of the investigation was lawful and non-political, but its expansion and continuance manifested substantial violations of DOJ and FBI protocols. There's more. FISA is not only unconstitutional, it is also inherently corrupting of government officials. When government prosecutors seek a search warrant pursuant to the Fourth Amendment, they are careful to document all their allegations. They know that if their target is indicted, that target's lawyers will have access to their applications for the search warrant and can challenge its issuance. In the midst of a homicide trial, I once reversed and nullified a warrant that I had issued 2 years earlier when I learned that the government had intentionally kept exculpatory evidence from me, evidence that, had I known of it, would have dissuaded me from issuing the warrant. That is the beauty of our due process. The adversary system exposes the truth. There is no such exposure under the FISA system, and FBI and national security agencies know this. They also know that their methods and applications to the secret FISA court will never be exposed to defense counsel or to the public. Well, up until now. Now we have seen in a case involving the President of the United States a material alteration of a document, reliance on unverified allegations, substantial omissions, agents duping one another, applications signed by senior DOJ and FBI folks who never even read, much less questioned, what they signed, all done with the false comfort that their misdeeds would not come to light. Why? Because they never thought Hillary would lose. My intelligence and law enforcement colleagues tell me that 2 generations of FBI agents have come of age believing that if they have a weak case, if they lack enough probable cause to obtain a search warrant, they can always get one from the FISA court. It's real easy. The FISA court is repugnant to the Constitution and to the concept of an independent judiciary, and it took an Inspector General report on the FBI and the President to demonstrate that. Unfreaking believable. Or is it? Take care.